Good afternoon. My name is S3 Gentry, and I am an attorney practicing in the National Vaccine Injury Compensation Program. And in addition to running my own firm, I am the director of the Vaccine Injury Litigation Clinic at GW Law School, just up the street. I was saying I drive past this building every Monday and Tuesday coming back from class. I have been a practitioner in the NVICP and assault, and that's been my only practice area for over 20 years. So the program's got me beat by about 10. It's just about 10 years older than I am in my practice area in that. I assume if you're not a vaccine injury practitioner, and I know most of the usual suspects, that you either don't know anything about the NVICP or what you know you probably got off the HRSA website, which I think is a bit of a dangerous proposition. So I'm going to give you an overview of the NVICP very quickly today. I'm sure I don't have to tell this group that vaccines are critically important to our national health policy. And the NVICP is a no-fault federal program. It helps the small number of people who experience a severe reaction or even death to vaccination. It was established in the 1980s, and one of the main problems with it that we're going to discuss today is that it's never really been updated. The types of reactions include relatively minor injuries to severe neurological damage, total paralysis, children on ventilators, feeding tubes, and adults who can't care for themselves anymore. The vaccine program has two types of cases that you file. There are table cases. There's a table of injury. You have to have a covered vaccine, which are all of the routine recommended childhood vaccinations. To have a table injury, the injury has to be listed on the table. It has to occur within the timing set on the table, and how it progresses has to meet the qualifications and age to interpretation in the bottom. Simply saying you have Guillain-Barré syndrome is not enough. You have to meet all the restrictive definitions in that. If you qualify for a table case, you have a presumption of causation and you typically go straight to damages. If not, you have a non-table case, or what we would call a causation in fact case, meaning you're going to proceed as though it was in regular litigation. While it's still a no-fault program, you don't have to prove fault. Make no mistake, this is a very adversarial and very litigious program today. The cases are challenged routinely by HHS, and the Department of Justice attorneys are zealous advocates for their clients. It is a tremendous issue, and the cases have become very costly because of this and challenging it. Right now, the overwhelming majority of the cases in the program are table cases, however, due to two facts: the addition of the cervic injury, shoulder related to vaccine administration, and Guillain-Barré syndrome following flu shot. As I said earlier, the program has never been updated. The infrastructure has never been updated. The biggest issue we have is the lack of modernization and particularly infrastructure in this program. We have 8 special masters that run this program. The program is administered out of the U.S. Court of Federal Claims, the Office of Special Masters. There are 8 special masters. If you're not familiar with a special master, we'll just call them judges. That's effectively what they are. They are the fact finders in the case. There are 8. There were 8 in the 1980s when they established it, when it only covered 6 vaccines. There are still 8, and we now cover 16 vaccines. The number of cases in the NVICP filed in the last 10 years alone has quadrupled, from 386 filed in 2011 to 2,060 cases in 2021. This is not, and let me be clear, this is not because vaccines are any less safe. It's because we added the flu shot, which instead of children, which is what the original program was created for, getting a limited number of vaccinations in a limited period of time, we're talking about everyone every year. That exponentially increases the ability or someone's opportunity to file a suit. More people are available to file a claim. So that's why the cases have gone up. Congress has never increased it or looked at it again. This has created an overwhelming backlog, right? There are nearly 4,000 cases in the program right now for 8 special masters. Most of these claims are in the server program or in this SPU program. We have a lot of alphabet soup in our program as well in Washington. The Special Processing Unit just means table claims. They're in there. They stay with the chief special master of the court. He has over 1,000 cases on his docket. Everyone else is spread out among the other 7 special masters. Right now, people are waiting 2 to 3 years to get a hearing scheduled, to get their trial scheduled. That's after spending probably at least 2 years getting to that point. The average waiting time for the government's response, HHS's response to our filed claims, is 16 months right now. The original language in the statute expected these cases to be resolved within 240 days. That's not happening under any circumstances. The special masters are working insanely. They're doing everything they can, but there's just no room on the docket. So imagine our two biggest categories are children with injuries and seniors with injuries right now. And imagine telling your 77-year-old client they're going to have to wait 2 years because they might not have met exactly the definition of GBS under the table. And we had to do that. I have recently, unfortunately, had a client pass away waiting for the government's response to a claim in a simple cellulitis case. So these are having real effects. The system is at a breaking point, and the staff and infrastructure to properly administer this program needs to be put in place. As someone who has been advocating on the Hill for over 10 years and seriously advocating on the Hill for the past 3 terms of Congress, 6 years, it is extraordinarily difficult to get movement on this. It's a huge problem for us. We are a tiny, tiny program in the scheme of things. But when you're looking at creating a new compensation program, the best advice I can give you is to build in an automatic ability to grow, because if you have to go back to Congress, which we do for increased special masters, you're never going to get it. Or I hope that's not the case. I hope we get them this term. We're asking again, especially with COVID probably coming over. That's it. So the other thing is, if you're going to do this in the NVICP, it has to be a reasonable and meaningful alternative to tort litigation. And for the most part of the NVICP's history, it has been. But in the past 10 years, there has been an aggressive pushback on these cases, a delegitimization of vaccine injuries overall, a denial of everything but used to we get reasonable settlements and things like that. And the result of that, and from HHS as well as from the Respondents Council, the DOJ, the result of that is you have the elimination of entire categories of injuries, as well as nearly the elimination of entire vaccines. And you could tell this by the HPV vaccine is the most critical one you could think of, right? The HPV vaccine, very few, a handful of cases have won on causation on HPV, and it's been on the table for years. The result of that is these cases are now proceeding in multi-district litigation in the civil arena, defeating the purpose of Congress. So if you have a compensation program that is effectively in name only and doesn't actually compensate things, then you're going to have people opting out. And you have to have an opt-out provision, I would argue, because it's a constitutional right. And if you're going to take it away, you have to have a meaningful alternative. And the purpose of the VICP program was compensation. And so in short, it has to compensate people. And it's not doing that right now. I'll give you one quick brief of what it is. And I found Jason's presentation very interesting. Our compensation has not been updated either. There are 3 categories of compensation in the vaccine injury compensation program, or 4 with the death benefit. There's out-of-pocket unreimbursable medical expenses or other related expenses. There's pain and suffering, and there's lost wages. Pain and suffering is capped at $250,000. So that number, it's still capped at $250,000. It's extremely difficult to tell the parent of a severely injured child or somebody who's in a wheelchair for the rest of their life that the max that they can get is $250,000. That needs to be updated, and Congress originally intended to put a COLA escalator in it, and they took it out in the end. But I would certainly recommend that. Lost wages for a child is a formula that's set by the statute. That's not going to change. There's no cap on lost wages for adults, so long as they can justify it. There's no cap on out-of-pocket expenses, and the death benefit is also still just $250,000, which is extraordinary. And only till recently was that all that they got. Recently, we had to fight up to the federal circuit to get a decision that said they could also receive incurred pain and suffering up to that point. But the program needs to be updated, and the compensation program, it can be very effective. I think it's necessary. You want people having these cases in there. Vaccine injuries are very rare, but it needs to be compensated. And for those of you, if you may not know, the compensation comes out of a fund. It's not an appropriations bill. It comes out of a fund that is from the excise tax from vaccines. Every vaccine administered per disease prevented is a 75-cent excise tax. There's nearly, I think actually just over $4 billion in the fund. And then the 34-plus history of the fund, they've never had to touch the principal in paying out. The original expectation, the CBO scored this bill, the original act, that 50% of the people would get full pain and suffering, and the other 50% would get half pain and suffering. And I can tell you that it's exceedingly rare for an individual in the VICP to get full pain and suffering at this point. Thank you.